Hello, I'm Angela Prinzel, and it's been a while since I last posted a video, and I do apologize for that. I plan to post more frequently going forward. Today, I just have a very short message, and really, in a simple sentence, it's do not count on your delay to get your matter adjourned. This is a reminder from a 2020 Ontario Court of Appeal case that I just ran across my desk recently because, as you could guess, I'm dealing with a similar situation where someone's trying to get a matter adjourned, and you have to wonder, are they, is the other side being strategic about delaying this matter in hopes that they would get an adjournment? And I mean, obviously, I cannot speak for the other side, but what I do want to make clear to people is you can't really be guaranteed that you will get that adjournment. So in this Ontario Court of Appeal case that I refer to, the husband was appealing a decision by a trial judge, and as part of his appeal, he believed that the judge made a mistake in not granting his adjournment request because his lawyer was not available to proceed to trial on such short notice. The Court of Appeal said no. The judge in this case actually was keeping with the interests of justice when he refused the adjournment. The trial judge considered that the husband knew about the trial date for 6 months before trial. He was aware for more than 2 months before trial was to start that his former counsel would not be representing him at the trial. This appellant also waited to contact a lawyer only a day before trial. And the judge also considered the fact that if the matter was adjourned, trial would not be heard for another year. Now, what many people don't realize is that in the family courts, we don't have trials, every month or whatever, right? So in the Superior Court of Justice, for example, the Unified Family Courts, there's usually trial sit-ins. There's set times when trials happen. In Oshawa, for example, you have, your main trial sit-ins are in May or November. So parties may have been waiting several months to get to a May trial date. This trial could have been set since January. If anything happens, it's on the party to do everything they can do to make sure that they're ready, willing, and able to proceed to trial. And to even put more of a context on this as well, is with family matters, you have, trial is not something that just springs on you. So you've most likely had a case conference, you've had a settlement conference, and you've also had a trial management conference. And sometimes even some of these conferences get duplicated. So, there's been ample opportunities. And if a party doesn't want trial, and that's kind of why they're just trying to strategically adjourn it, a better approach would be to settle, to try different strategies for compromise, for settlement, or even completely moving the matter out of the court system and seeing if there's other ADR approaches that might be able to get a quicker, more cost-effective resolution. But waiting a day before trial to seek an adjournment, or a week before, thinking that, well, if I'm not ready to proceed, or if I get a lawyer and my lawyer is not ready to proceed, the judge might have no choice but to adjourn my trial. Well, that's faulty thinking, and you've been warned. Do not count on your delay to get your matter adjourned. So all the best, and I will be back talking to you soon. Bye.